Rodney from MaxPeoplePerform. Today I'm going to talk to you about a very important topic in HR and employment law, employment agreements, and the importance of having valid and enforceable employment agreements in your work environment. When we speak to our clients, we think of employment agreements as the single most important tool that an employer or manager can have. And I want to talk specifically about 3 myths of employment agreements. Myth number 1, it's not necessary to have one in the work environment. Unlike a prenup agreement, which many people might not believe is good for a marriage, we believe that employment agreements are fundamental to the employment relationship. Sets out the terms and conditions of employment, does so in an unequivocal, unambiguous manner, and lets people know, both the employer and employee, what are the key elements of the relationship. There's nothing more that you can ask for on either side of the relationship. Myth number 2, you can have an employment agreement signed after the person starts working. Very important, like with any contract in any area of law, that an employment agreement is signed prior to the person starting to work. So suppose you have this policy of people starting to work and then signing agreements 3 months into their job. It's not going to be held to be enforceable if push comes to shove. So it's really important that prior to someone starting to work, to have it signed off and executed. Similarly, if you're promoting someone in your workplace and you're giving them a more substantial role, greater compensation, etc., it's equally important to have an employment agreement signed off prior to the promotion actually taking effect. And finally, myth number 3, don't include a termination clause because it might turn people off. Well, this is, again, a myth because we believe setting out the terms and conditions if a relationship doesn't work out at the outset just makes things much easier in the event that the relationship derails or for some reason doesn't work out. By having a termination clause in place that's valid, the employer will know what they owe the employee and they can choose to give more if they want, and from the employee's perspective, they know what they're getting. So those are 3 myths that we hope we've been able to dispel today. And if you have any other questions, please call us on HR or any other employment law issues at 905-709-1236, extension 101.